And this, as you will recognize, is a perennial problem in litigation. One of the first things a dispute lawyer is taught is, what is the limitation period? Ask yourself that question every time you're involved in a new case. And that applies either if you're acting for the claimant, crucially, you need to issue the claim form within time, or a defendant, where you may need to plead a limitation defense if you think you've got one. And it does puzzle me as to why this is such a problem in practice, because the limitation periods are for most claims quite generous. For breach of contract, for instance, 6 years from the breach. And thinking about this, I decided there were at least 4 reasons why the limitation period is such a problematic date in many situations. Were the facts which were based on the defendant's defence as far as the claimant's new claim would be concerned, were those already in issue on the claim already made? Well, what the Court of Appeal said in Good and Martin was, yes, they are, because to determine the claimant's existing claim, the court has to determine the effectiveness of the defence to it, and the facts involved in the defence are already part of the factual inquiry, and therefore to base a new claim, if you're the claimant, on the facts involved in the defendant's defence is legitimate, because that claim, which the claimant wants to add, does arise out of the same facts or substantially the same facts as are already in issue. I've been looking at the threshold conditions and the court's discretion, if the threshold conditions are met, to add a claim or party out of time. But let's look at the reasons why an applicant may want to do this, and the applicant will be the claimant in these scenarios. So first of all, if the applicant considers the new claim is essential to its prospects of success in the litigation, that is a basis on which he may want to apply. If it's not essential, it just would be a nice to have, but the limitation period has expired. Well, I wonder whether it's worth applying, because you could end up with a adverse costs order if you don't succeed. You may waste some time, and also you may lose momentum in the litigation if the defendant has rebuffed the application.